Welcome to the Appellate Division First Department. We have over 6 hours of argument time requested today. Therefore, only ask for the time that you need, not that you want. We have thoroughly reviewed the records and the briefs and are familiar with the case. If we have additional questions, we will go over the time. People versus Bookman. Appellant? 4-1 and 4. Cayley versus Cayley, and Justice Moulton is recused in that matter. Appellant?
4 and 1, Respondent?
Respondent? How much time do you want?
4.
Okay. 4. Catherine versus Evelyn is submitted. Costanita versus Premier Company. Appellant?
Appellant number 4-1, please.
I'm sorry, what'd you say?
4-1, please.
4 and 1. Outsect? Is Outsect not here? Okay, is anyone here from Premier?
Yes. 4 and 1.
You don't have a cross appeal though, do you? No. Okay, so you just get your 4 then. Genovese versus Nation Star Mortgage. Appellant?
Appellant Genovese, 7-3, Your Honor.
Respondent?
Respondent,
7-1 and 7. People versus Murtha. Appellant?
4 and 1, please.
Respondent?
4.
4-1 and 4. Subway Real Estate versus Jahidi is submitted. Board of Managers 15 versus BCR 15. Appellant? Is anyone here for respondent?
yes, Your Honor.
Do you wish to submit it? Oh, you here?
Yes.
Oh, I didn't see you over there. I'm sorry.
4 and 1, please.
Respondent? 4-1 and 4. Hogue versus Board of Education. Appellant?
Jimmy Wagner for the appellant, 12 and 3, Your Honor.
Respondent?
5 minutes, Your Honor.
5-1 and 5. People versus Norwood. Appellant? Respondent?
3 minutes, Your Honor.
3-1 and 3. JLJ Children. Appellant? Okay, that is submitted. People versus Collins is submitted. Bick versus Bick. Appellant? Is respondent here?
I'm here, Judge.
You want to submit?
I think they're supposed to be here. I talked to them this morning. They said they're coming.
Have we heard anything? No? I mean, if you want to wait around, but if they're not here by the end of the call, the calendar,
I'd like to wait till the end.
okay. But otherwise, is submission okay? Okay. So let someone know if they do come in by the end of the call, the calendar. Newby versus Morales is submitted. People versus Santos. Appellant? Are you respondent? Do you wish to submit?
Yes, Your Honor.
Okay, submitted. Smith Gambrill versus 3 West 16th Street. Appellant?
Appellant, Your Honor, 62, please.
Respondent?
4 and 4.
6-1 and 4. Rivera versus Board of Trustees. Appellant?
Appellant 4 and 1, please, Your Honor.
Respondent? 4-1 and 4. Richardson versus Motor Vehicle. Appellant?
Appellant, 5 and 1, please, Your Honor.
Respondent? 5-1 and 4. People versus Mohammed G is submitted. People versus Savage. Appellant? 6-2 and 6. And Marini versus Thurman is submitted. 1591 Second Avenue is submitted. And the first case is People versus Bookman.
May I proceed? Good afternoon, Rebecca Besden with the Office of the Appellate Defender on behalf of David Bookman. The accusatory instrument charging Mr. Bookman with criminal contempt in the second degree is jurisdictionally defective and must be dismissed. The only disputed fact here is whether the accusatory instrument sufficiently pled knowledge, specifically whether it's sufficiently established that Mr. Bookman had knowledge of an ex parte order.
Counsel, you concede that bare bones allegations are sufficient.
Allegations, there must be facts of an evidentiary character to establish each element of the offense. That's the statutory requirement for an information, which respondent concedes applies here because prosecution by information was not waived at the time.
So if that's the case, why isn't an allegation of mailing sufficient?
The allegation of mailing is not sufficient because most glaringly, there's no date of mailing provided. The order of protection was issued ex parte. The phone call in question asking after the well-being of Mr. Bookman's daughters was 8 days later. So whether or not he would have received the order of protection and been aware of it and his contents would hinge on whether it was mailed in a timely fashion, whether it was mailed on a date which would have caused him.
We presume that it was actually mailed in a timely fashion because that's exactly what the statute calls for.
The statute actually, well, a couple of things. First of all, the accusatory instrument does not specify who mailed it, whether it was the court, the complainant, or the sheriff, or any other individual.
So why shouldn't these issues just be addressed as evidentiary objections rather than a pleading sufficiency argument?
Well, it's well established that at the pleading stage, there must be evidentiary facts to support each element that are non-conclusory.
As my colleague stated, it's a very low bar, what's required for a pleading versus what has to be proved.
Yes, but at the same time, I think it's important to keep in mind that because a misdemeanor defendant does not have the protection of a grand jury or a preliminary hearing, a misdemeanor defendant may be held for trial and incarcerated solely based on an information. The Court of Appeals has observed in Alejandro that that's why there is this heightened standard that's been upheld again and again, and that there really need to be evidentiary facts which support each element. Here, the accusatory instrument is equally consistent with guilt and innocence. There's simply no basis from which to infer that Mr. Bookman would have received the order of protection before the phone call as opposed to after the phone call, and those facts do need to be in the accusatory instrument. I would add that the allegation that it was mailed to Mr. Bookman is similarly problematic and conclusory because there's no source given for the address. There's no indication whether it's his last known address, whether it's an address from the DMV, whether the complainant told someone that this was his address. And that's another instance where there need to be evidentiary facts supporting that he would have actually had knowledge of this order of protection.
Counsel, what are we to make of the fact that upon arrest he said, "I didn't call her, she's lying"? Doesn't that show some knowledge of the order of protection?
Well, two responses. The first is that that statement comes from the VDF, and under the Four Corners rule, only information within the four corners of the accusatory instrument and annexed documents can be considered in the analysis. There's no allegation that the VDF was annexed to the accusatory instrument, but furthermore, that statement...
Just to interrupt you, doesn't that prove Justice Kern's point that really what we need here is an evidentiary hearing?
No, Your Honor. What that establishes is that the facts necessary in the accusatory instrument are not there, and whatever is in the VDF cannot be considered at the pleading stage. And I'd just briefly add that there is no reference to an order of protection anywhere in the statement in the VDF, even if it could be considered.
Thank you very much.
Thank you.
Good afternoon, and may it please the court, Catherine Murata for the people. Here, there were sufficient facts to establish that the defendant had knowledge of the order of protection when he violated it. As Your Honor said, bare bones allegations are sufficient in an accusatory instrument.
Well, then what distinguishes an information from a complaint?
There's a two-pronged standard for an information. You need to have reasonable cause and non-hearsay allegations, whereas in the misdemeanor complaint is just the reasonable cause element. But under this higher standard of the information, this instrument passes muster. This court can consider facts expressly alleged in the complaint, as well as reasonable inferences and obvious implications from the instrument. The order of protection was issued on September 21st, 2018. and defendant made the phone call 8 days later. It is a reasonable inference to assume that he received the order of protection by that date and knew that he was violating the order of protection when he did so. Furthermore, defendant called from a blocked telephone number, which indicates that he knew what he was doing was wrong and he was trying to avoid being criminally charged. To the extent that the instrument lacks a mailing date or the defendant's address, these are evidentiary defenses to be raised at trial, where a defendant could have had the people prove beyond a reasonable doubt the knowledge element. Here, the
It's really
standard.
the temporal element that's most important here, right? And that's what got the prosecution into trouble in the People versus Roman, People versus Del Vecchio, and the Appellate Term Second Department, which I think are those cases seem to me to be on point to this situation here.
I think those cases where the facts are more conclusory, where they didn't really address how defendant had the basis of knowledge, where here it was that he was mailed to the defendant. And the core concerns of jurisdictional sufficiency is that there is a sufficient notice for the accused to prepare a defense. And I think that even though maybe this was bare bones, this was sufficient for a defendant to provide a defense. He could have raised that he didn't receive the accused or the order of protection. And these allegations are sufficient, and if there are no further questions, I ask that you affirm. Thank you.
Thank you very much.
If I could just first very briefly respond to a respondent's point about the blocked phone call. I just think it's important to note, we all know calls come in from unknown numbers for a variety of reasons other than the caller is specifically aware of an order of protection which prohibits the phone call in question. And additionally, the allegation is that the call Mr. Bookman made, he referenced the shared daughters. There's no allegation he was trying to hide his identity or anything of that nature. And regarding the reasonable inference that it would have been done immediately, I just want to stress that neither within the four corners of the complaint or elsewhere has respondent been able to point to a single source which says it is the regular practice of family court to do immediate mailings. And to the contrary, the sources cited in our brief reference that personal service is the norm, and if not personal service, a specific type of substituted service, the facts described in this complaint bear no resemblance to the regular practices outlined in Family Court Act. And so there's simply no basis whatsoever upon which to base an inference that
Thank you.
a regular source would have been to mail it immediately.
Thank you very much.
Thank you.
Just one moment. On Bick versus Bick, I have been told that the appellant has appeared. I'm going to give the appellant 6 and 1, and I'm going to give the respondent 6 minutes of time on that.
Your Honor, we do have a cross appeal. I'll take 5 and 1.
You're right. Okay, 5 and 1. The next case is Cayley versus Cayley, and Justice Moulton is recused on that matter.
Good afternoon, Your Honor. Stephen Cooper on behalf of the beneficiary of the Roberta O'Cayley 2017 Family Trust, Lee Cayley. Your Honor, we're here because the lower court denied my client an accounting of a trust that really, in our view, has no basis. The reasoning, and there was no case support for the reasoning, was that there had been no showing of misappropriation or misallocation.
Let me ask a question. Sure. Why do you need the accounting at this point? Since it's undisputed that the funds have been returned and that you have the relevant documents, what's the necessity for an accounting?
Well, first of all, there's another piece of property in the estate, which we know very little about. There's a residence, and the respondent, Gloria Cayley, in her answer denied having any knowledge of that. And then we found through a production that there were 2 checks that she had signed within the last year to tax authorities. So we don't know anything about that. Secondly, there are a lot of unanswered questions about this whole thing. If there was a standard that you had to show some wrongdoing, I think we more than satisfy it. The funds were taken out of the accounts 4 months before we discovered it. When we wrote to Ms. Cayley's attorney, she denied everything. She knew nothing about it. Then a few months later, she said there was a fraudulent signature. Then she said, you know, they're investigating it. Finally, we ourselves, she should have had the bank accounts. She should have had the trust agreement. She's been completely remiss, if not, you know, totally reckless in this. She knows nothing about nothing. And then when we brought it to her attention, 4 hours later, we get an explanation from her that they figured out that somehow they had been transferred, some money had been transferred, and she'll return money from one of the two accounts. We asked for information about the investigation. We asked for information to what accounts this went into. We asked for information as to why this happened because she claimed that she had gone to the bank and wanted all of her accounts closed, and they mistakenly did this. We asked for all this information, and instead of Ms. Gloria Cayley fulfilling her fiduciary duties, doing the right thing, she wrote back denying all liability, reserving her rights, and telling us this isn't discovery. We would like to know exactly what happened here, and we'd also like to know whether the books and records were maintained in a proper manner. The case law we cite is overwhelming. Virtually every year this court has held that if there's a fiduciary duty, there is an absolute right to an accounting. No other showing has to be made. We don't have to show that there's no other remedy of law. There could be other productions. There could even be a full production. This is an absolute right that's triggered. We have 6 or 7 cases from the last few years from the First Department. So given both the fact that the law is overwhelmingly in our favor and the fact that there is a lot of suspicious activity that went on here, we need this accounting. The final point I'll make before I sit down is there's some argument about the fact she's no longer a trustee, and that was thrown in by the judge, also without support. But the case law is clear that after a trustee ceases to be a trustee, that's when an accounting generally occurs. And in fact, under Tidings versus Greenfield, the statute of limitations doesn't even start to run until that person is replaced. So there's also no valid reason based on the fact that she's no longer a trustee. So based on all these circumstances and the strong law, we think it was a mistake by the lower court. We should be given accounting. We should be able to look at what happened here. And then if there's other wrongdoing, we can make a breach of fiduciary duty claim. But we don't have to show the breach of fiduciary duty, though there are grounds for it already before we actually get the accounting.
Thank you.
Good afternoon, Mark Rogovin from Hackeiser and Akmal for the respondent, Gloria Cayley.
What is your response to the overwhelming case law, which is very, very clear in black letter, that there's an absolute right to an accounting in these circumstances and that you don't have to show any wrongdoing or anything of that nature in order to be entitled to an accounting?
Well, I think that case law is distinguishable for several reasons, and I think we addressed that in our papers, but just briefly here, the cases cited by appellant in support of that absolute right, they're factually opposite. Those cases all turned on the existence of an ongoing fiduciary relationship as well as other distinguishable facts. Here, there is no ongoing fiduciary relationship.
But aren't there a number of cases that are very broad in their language, separate and apart from the facts of each case, that the right is automatic, it's absolute, there's no exception, no showing is required, it's just what has to be done. So how do you distinguish that? It's just what has to be done. So how do you distinguish that law?
Right. Well, I would say that those cases, while they do use broad language, I would submit that the court still has discretion to not order an accounting, to deny a claim where.
Why would a court not order it where the right is automatic and absolute? Why would a court exercise its discretion to say, no, in this particular case, we're not going to order when there's no showing required to be entitled?
Because in this particular case, Your Honors, as we laid out in our papers, Ms. Cayley not only did not object to the subpoena that appellant served upon Citibank for the bank records relating to these accounts, she conducted her own investigation as well and restored all funds with interest in full during that investigation. So there's been no showing of any harm to the trust as a result of this alleged misappropriation. In addition, all account records, as I said, were subpoenaed by the appellant directly from Citibank. There's never been any indication from the appellant that those records were insufficient in any way. Those two facts, plus the fact that Ms. Cayley is no longer the trustee, having been removed, I think allows the court discretion to deny the accounting. I also just wanted to point out in response to counsel's comments, with regard to other assets, there were no allegations with regard to any other assets. The only assets that were at issue here were the trust funds, which were restored in full with interest. The other asset that he's referring to, the property we believe to be Miss Roberta Cayley's home, isn't at issue in this accounting. There were no allegations about any other
Is
property.
that part of the trust? Those assets, the home?
Well, there were no allegations made about those assets. The home is lived in, to our knowledge, by Mrs. Cayley, Roberta Cayley. There was no request for any information about those assets. To the extent anything was requested in the subpoena, it was produced by Citibank. So Ms. Cayley has no other.
So they were inquiring about the bank account.
They were inquiring only about the
bank account. But as the trustee, isn't she required to do an accounting to account for all of the assets in the trust?
Yes, the assets, the information that was sought by appellant here, all records were provided, not only in response to the subpoena, but also the records of Ms. Cayley's personal investigation and her correspondence with Citibank. To the extent that they seek any additional information, all the information that they are seeking is contained in those records. Ms. Cayley can't produce anything else. She is no longer a fiduciary, no longer has any access to the trust assets and accounts. The information that they're seeking is the very same information that they would receive if an appellant was, if respondent was compelled to account.
But how do we know that?
Well, there are no other. They've sought no other records. The records that they sought were from Citibank. Those were the trust account records. So the information that was provided in those records would simply be digested in a different form in an accounting, but it would be the same information.
Thank you very much.
We don't know what we don't know. And we did request additional documents, and the letter we got was back from counsel was, this isn't discovery, you're not entitled to that, and we reserve all rights and we admit no liability. We asked for a complete accounting, Justice Mendez. We want accounting of all the property, the bank accounts, and the home, the residence, the real estate. We want to know what bills were paid on that. This generosity about them putting back the money was months later, only after being confronted with the records that my client subpoenaed from Citibank. These are bank accounts that should have been in Gloria Cayley's files. She is a trustee of a trust that has bank accounts. She did not have any of them. She did not have the trust document. She did not know anything about the house. I mean, this is a very ugly situation. My client needs to get to the bottom of this.
Thank you.
Okay.
Thank you very much. Castaneda versus Premier Company.
May it please the court, Jeff Sheetzel for the plaintiff appellant. Your honors, this case generally boils down to, at its core, was this protected work? We have several questions presented, but I submit to you that it becomes easy once we decide, was this protected work under the labor law? The respondents have referred to it as mere pest control. But what I would submit is that it can be more accurately described as construction of a permanent apparatus that would ultimately aid in pest control.
Counsel, even if it was construction of a permanent apparatus, doesn't it have to be to the building or what structure? How did this work have anything to do with the building itself?
Well, there were...
Even if they annex something to the building.
Sure, thank you. There were upwards of as many as 300 holes that were drilled into the building, and permanent eye loops put in the building that remain to this day, that were meant to attach this netting to. And if I could leave the court with one impression today, I would say you don't show up to do pest control with an impact drill. This guy was using a hammer drill, he was using mortar, it was plywood, it was a 40-foot ladder, and the measure of whether or not this is protected work is the entire scope of the 3-day project, not just what he was there to do that day. And the scope of the entire project was, again, it was the drilling of 300 holes.
But was he repairing the building or the structure?
He was making a material alteration, which makes it protected work. And which brings us to the distinction between, was this repair or was it routine maintenance? And this was the 3rd day of a job, which was intentionally spread over several days, because as the testimony indicated, you've got, when you install these anchors, sometimes some of them come out. So you want to go back and be able to troubleshoot it. And if it was just that, maybe the respondents would have a point. But what we had in this case was that one of the tenants had thrown something down and destroyed the netting that they'd installed on another day, which was supposed to last 5 to 15 years. So the idea that replacing this destroyed netting 2 weeks later amounted to routine maintenance and something that was expected.
And how was the netting part of the building itself? The netting was something that was attached to the building, but it wasn't a repair to the building.
Again, it was
a repair of the structure that was supposed to keep the pigeons away.
It was the scope. It was the scope of the entire project that we're resting on, Your Honor. It's the drilling. It's the drilling into concrete. It's the mortar, and as we cite in the cases that in our brief, for example, Joblon was a case where chiseling through a cinder block to get to the other side to run a wire to mount a clock, that was protected work.
Joblin engaged or involved connecting a power source too as well, right?
Pardon me?
In Joblin, it wasn't simply chiseling through the wall. They also had to run a power source.
Right, electrical cord through the wall.
That seems to be more of a significant change than drilling almost superficial holes in the superstructure to install netting.
Well, the cases that we cite, including Belding and Weininger also, they're essentially just running cables through pre-drilled holes. It's a guy going up into a drop ceiling and moving one panel and running cables through pre-drilled holes. Weinberger was a series of holes punched out that where they were allowing internet cables to pass through the ceiling.
Counsel, could you speak to, maybe you should do this on rebuttal, but I'm interested in hear what you have to say about Labor Law 200. But that can wait till rebuttal.
Okay, yeah, you could address it in rebuttal. Go ahead, counsel.
Your Honors, my name is Stephen Balson-Cohen. I represent Premier from Perry Van Etten, Rosansky, and Kuttner. I'll keep this very brief. Every pest control job is different. So protecting against birds, it may be different than protecting against cockroaches. Plaintiff is focused on the ladder and the nails, but loses sight of the overall what was meant to be done. Mr. Maldonado testified that these nets themselves are not permanent. They have to be replaced and maintained, which is maintenance. We have a situation, and I can tell you, if you refer to the record on page 756 and 757, you'll see Mr. Maldonado. So the record is uncontroverted in that regard. Number two, the plaintiff knew why he was there. He said that they was there for pest control. Pest control is not an alteration of a building or anything protected by the labor law. Finally, I'll leave you with the words of Diabolon, that not every use of a ladder or a nail signifies a labor law protected activity. It is important to note, finally, what Holler versus the City of New York said, where work does not involve a significant or permanent physical change, dismissal of a labor law claim is appropriate. I believe the lower court got it right, and I ask you to affirm their decision.
So,
Go ahead. What about Labor Law 200? Why isn't this like a negligence case? I know common law negligence is still in the case, I believe, correctly?
Correct.
All right, so why not Labor Law 200?
Because we don't have a traditional construction site. Even Labor Law 200 requires some indicia of protection by the labor law. You have to raise the indicia of a protected activity under Labor Law 200. You just can't, otherwise you wouldn't need Labor Law 200. You could have labor law, you can just have common law negligence. If you have common law negligence, you don't need Labor Law 200 because there you have a different type of even strict liability, which would not be raised in this case if it was merely maintenance.
Any more questions? Thank you very much.
I just had one, I'm sorry. So we're talking here about whether or not there's an alteration, and that involves the significant physical change to the configuration of the structure. How is this any different than, say, Belding, where they were just applying a blast film to windows on a completed structure?
Well, because that film actually changed the character of the building. This particular thing is, and you don't have to take my word for it. If you go to the record, starting at page 352, you can see the pictures. You can barely see the netting. That protective film altered the nature of the building. This does not. And I submit that if you take everything that has been said, plus the pictures, which I believe are in color, that Your Honor, it's certainly edifying.
Thank you.
So with respect to the 200 claim, it comes down to who directed and controlled the work, right? So
what evidence is there that we don't have outcasts here right now, but what evidence is there that Premier actually supervised and controlled the work?
that Premier did.
Well, that's
Well,
here, so.
those claims are generally geared towards outsect.
Right, but they both appealed. I mean, that's part of the appeal before us, and since Outcast isn't here, what's your argument with respect to Premier? Since
Well,
that's still a live issue on the appeal.
With Outcast,
Or are you conceding that there's
I'm
no
conceding
200
that.
claim against Premier? What?
I'm conceding that
Okay.
with respect to this
Okay.
respondent.
You could make your statement with respect to Outset, because even though they're not here, we're going to have to decide that issue.
With respect to Outset, it's very simple. They've admitted that Mr. Maldonado was a per diem employee. While they didn't know exactly who our client was, Mr. Maldonado told them that he was going to have to bring in another guy. So there was an expectation that he was going to be there. There's no dispute that Mr. Maldonado was the senior guy on the job, providing the instruction. And the GC's contract, or Outset's contract with the owner, said that they were responsible for workplace safety, including fall protection.
Okay, thank you very much.
Thank you, Your Honor.
Genovese versus Nation Star Mortgage. Go ahead.
May it please the court. Good afternoon, Your Honors. My name is Dan Paternak, and I represent the appellant in this matter. We ask this court to vacate the decision of the Supreme Court, and by that, we're seeking to dismiss or reverse the granting of a motion to dismiss filed by respondent Nation Star Mortgage for several reasons which we have briefed. And there is one important matter that we just not realized, but we were informed of a little bit more than a week ago that is important, very important, because it affects this decision. We learned on Labor Day weekend that respondent Nation Star Mortgage assigned the mortgage to another lender prior to the commencement of our action. And we had no knowledge of this because the assignment prior to the commencement of this action wasn't recorded for at least 4 months. So when respondent Nation Star responded to our case by this form of motion to dismiss, we never looked after that because they were represented by counsel, and this has been active litigation for 1.5 years, including this appeal.
But I don't think that, to be frank, is part of the appeal.
So-
We only can decide this appeal based on the record as it came to us. So depending on how this goes for you,
Yeah.
this might be a basis for re-argument or to bring up below, but it's not something that we would be able to address. So I'm going to ask you about something that's a little
Sure.
further deeper into the argument, but to me it's a fascinating issue, which
Yeah.
is if we assume that FAPA applies and it stops them from asserting the acceleration, what about the retroactivity argument?
Yeah, that's a
That
fascinating.
it shouldn't be applied retroactively.
Yeah, it's a fascinating argument. So, the legislature, explicitly created this statute to stop defenses like the ones respondent Nation Star has brought forward. They want to eliminate these claims, and they want to eliminate the incertitude of these claims for families. So with regard to the retroactive effect, one, there's a clear rational basis for the legislation, that being what I just described. The legislature wants to end this incertitude for homeowners. Second, with regard to retroactive effect, and I have it in my papers, if we were to accept the position of respondent Nation Star that this should not be taken into effect until prospectively, then basically that legislation will not have effect for at least 6 years. Because what they're claiming is any prior action prior to the date of the legislation, well, that has a retroactive effect, so it won't apply to it. And that's why.
The argument that it interferes with vested rights and that's
Oh,
not permissible.
yeah.
He's not excited to answer that, sir.
I am. So the vested rights claimed here, they're claiming is the decision which we're actually appealing. So for purposes of Respondent Nation Star, they don't have any vested rights. It's a pending litigation still in front of the Supreme Court on a motion to restore, which even if there wasn't a motion to restore, Supreme Court still has jurisdiction pending this appeal. Second, Your Honors have the active litigation, so there is no vested rights with regard to Nation Star. Now the
What
issue
about the
itself,
vested rights with respect to the prior decision,
the prior decision, so vested rights
which
with regard.
dismissed it?
Oh, yes, fascinating as well. The prior decision actually doesn't vest any rights with regard to what it is that they're claiming. The decision below simply states that there was no personal jurisdiction over the estate. That doesn't help Respondent Nation Star in any manner. That's not a vesting similar to what the Supreme Court did below here. Essentially, the decision from the 2009 case that vacated it because there was no personal jurisdiction is not a vested right for Nation Star. I think what they're claiming was the vested right was the decision from recently in this case. Now, there is another case which was cited in respondents' papers, and that I think we came to issue with what you're getting at, Judge Kern, which is there was a case pending. There was a foreclosure and sale, or foreclosure judgment granted and sale, foreclosure judgment and sale granted, and the sale kept getting delayed over and over and over and over and over again. And the court in that matter essentially stated no, they had received vesting rights because the judgment and sale had already been entered, and that is what had vested. However, that's not the case here, Your Honor. And explicitly, when you look at the statute, there has been no judgment of foreclosure of sale in this case. That's why FAPA applies, and that's exactly what the legislature said. I think we would have a different argument, and I would probably find some other reasoning against if there was actually a judgment of foreclosure and sale, but that's not the case here. It's the exact
nothing
opposite.
vested by the mere dismissal of the case, no rights vested.
Are we talking about the 2009 decision?
Yes.
Or the 2009 case? Yeah, no. When you look at the decision and what the decision did, it basically stated that they had no personal jurisdiction. So we get back to what this case is really about. And what this case is really about is whether or not the loan was accelerated by the overt act of filing the summons and complaint. And what this court has is two examples. The law is scant with these exact facts. And there's really just two cases that have the exact facts that we do. There's one in the 3rd Department, which is the Stewart case, and then there's the Westchester County Supreme Court. And what Judge Ruderman did in the Westchester County Supreme Court was follow the principles, the controlling principles of Albertina v. Rosba, which has been the standing law in this court for the last 90 years. Essentially, what the Westchester County Supreme Court said was, we're not going to confuse the notice or service of the election, or the fact, I'm sorry, we're not going to confuse the fact of election with the notice or manifestation of the election.
Let me backtrack for a second. Do we need to get to the merits of whether or not there was an acceleration now that we have FAPA? Doesn't FAPA
In my
say-
opinion,
doesn't
no.
FAPA say we don't even need to address that? The first thing we need to address is whether FAPA applies, and if FAPA applies to stop them, then we don't even need to address the argument.
We don't need to. And FAPA truly applies
Why
when
does
you look at
FAPA apply?
because the plain language of the statute essentially states that if in the 2009 case, the issue of acceleration was not raised and there was no express judicial determination on the issue, then you cannot apply or assert the defense that the statute of limitations has not expired. That's the new
Your argument-
213B.
Your first argument is that we don't even need to get to the argument you just made, that
We don't.
we should just decide FAPA applies, it's retroactive, and therefore they're stopped from asserting.
That's absolutely correct, Judge Curran, and that's what the legislature wanted to do. They wanted to avoid arguments like this from Respondent Nation Star Mortgage.
Okay, let me hear from your
Thank you, Judge Curran.
counsel.
Good afternoon. May it please the court. My name is Alan Kaufman of Nelson Mullins. I'm here today on behalf of respondent. I obviously heard the panel's questions regarding the application of FAPA, but let me just, to the extent we want to get into the underlying issue, which I think is more direct.
So why doesn't FAPA apply, though? Why
well,
don't you first argue, since that is the first and central issue that we have to address in this case, why doesn't FAPA apply?
Well, first of all, I don't think FAPA would apply to either of the two actions that have taken place because FAPA, by its terms, says it doesn't apply to any action in which a final judgment has occurred. We have a final judgment in this quiet title action. So it wouldn't apply in the quiet title action.
But no, when you look into a judicial determination, you're looking to the prior action, not the present action.
Well, I think the way that FAPA would play out here, Your Honor, is to the extent there's a subsequent foreclosure action, then borrower could make the assertion that FAPA would apply.
Why you look at FAPA and it says, in an action such as this to cancel a mortgage, FAPA applies on its face. You have to look at whether the actual aspects of FAPA apply, right?
It says FAPA would not apply to an action where a final judgment.
This is an action seeking a cancellation of a mortgage, right?
Correct, but we had a final judgment before the enactment of FAPA. So because we had a final judgment before the enactment of FAPA, FAPA on its own face, Section 10 of FAPA.
Wasn't that dismissed?
Yeah, what's
No, this is the quiet title action. The quiet title, the judge found in the quiet, so the first.
This is an appeal of that case.
Understood.
That's the case we had before. So you're saying there was a final determination, but it wasn't final because it was being appealed to us.
Well, Your Honor, again,
So
I don't
it's
think.
not final. That's our job to decide whether the judge below got it right or wrong.
Understood, Your Honor, and that goes to the issue of acceleration. But I think FAPA on its face was not meant to apply retroactively. It talked about the idea that it wouldn't apply to final judgments. It also talks about the idea of take effect immediately. There's nothing in, and we put this obviously in our brief, and we
You're
cited
arguing
cases.
that FAPA is not retroactive. That's
Correct, and that it would be a deprivation of rights. And we.
What about opposing counsel's argument that if FAPA is not retroactive, then we have to wait 6 years before we can apply FAPA at all?
Well, FAPA would. I don't know why you'd have to wait 6 years. FAPA would apply to any newly filed foreclosure action.
No, because FAPA specifically asks you to look at the prior action and what happened in the prior action. So for that to happen, you'd have to wait years to be looking at a prior action.
Well, let's say that the appellant had not filed the quiet title action, and there was a foreclosure action pending now, today. That he would now have arguably a defense. I'm not saying it's a viable defense, but he would have a defense under FAPA. That's not waiting 6 years. The only difference for this case than a lot of the other foreclosure actions that are pending is that appellant brought this quiet title action.
Let me ask you another question about the retroactivity. The FAPA is described as a remedial legislation designed to clarify the meaning of existing statutes, codify correct judicial interpretations, and rectify erroneous judicial interpretations. Doesn't that language imply that we're going to look backwards at what has been done and try to correct things that have been done incorrectly?
No, Your Honor, I think it talks about remedying a perspective going forward. It said it takes effect immediately. There's nothing in any of the legislator notes that indicates it was meant to be retroactive.
Doesn't it say it wants to rectify past incorrect judicial interpretations?
Well, that's the explanation for why it's taking the actions that it did, obviously coming off the Engel case. But reality, there's nothing in there to directly state that it's going to be applying retroactively. And again, we've cited many cases and authorities that say it's got to be explicit and there's standards involved and the constitutionality. I won't take up the panel's time with all that, but basically it's got to be very, very clear when a law, particularly a statute, particularly a procedural statute, which is what FAPA is meant to apply retroactively. So I don't think FAPA would apply retroactively to a quiet title action because thinking about it for a second, the appellant essentially wants us to say, well, you're not allowed to argue what you argued 2 years ago, which is the legal nullity. And bear in mind, I'm not even sure that FAPA is not.
Isn't that exactly how FAPA is worded? That you're stopped from asserting the statute of limitations, from
prospectively, not retroactively.
But based on what happened in the prior action.
You can't undo what we did 2 years ago and make the assertion. And by the way, I'm not sure that, I would submit that FAPA was satisfied, right? FAPA is basically saying is you have to get a determination that there was no valid acceleration or there was de-acceleration. Here, we have a determination bearing in mind that
FAPA says you look at the prior action, did the court make an express judicial determination that the instrument was not validly accelerated? So we go back to that prior action where the court dismissed it based on the death. There was no express determination in that prior action about acceleration. So why doesn't the terms of FAPA apply in its favor?
Well, I think there's two distinctions that we have to make here as to what that prior order did. Number one, you have to look in the context of what the appellant did, and they argued that the prior foreclosure judgment should be vacated because it's a legal nullity. And that's really the issue I think that's before this panel, is about whether legal nullity can or cannot accelerate. But the other interesting thing here, the other thing that's unique, because not only do we have the same party and the same counsel, we also have the same judge. So in essence, what this judge did in the quiet title action is the judge said, yeah, my prior dismissal was based upon the idea that the legal nullity could not apply. So we now have—
But FAPA says to go look at what happened in the prior action. It doesn't say to look at what happened in the subsequent action. You're trying to bootstrap what happened in the subsequent action, but FAPA expressly talks about looking at what happened in the prior action. It says, unless the prior action was dismissed based upon an express judicial determination made upon a timely interposed defense that the instrument was not validly accelerated. So by its very unambiguous terms, you have to go look to the prior action.
Well, Your Honor, I think the question begs the problem, which is why we're supposed to ignore what the judge did prior to the enactment of FAPA and look back to 2017, long before FAPA was a glint in anyone's eyes, that the judge didn't know that he was supposed to have said that, even though we know from his decision on the quiet title action, that's what he meant. We know that he dismissed it because it was a legal nullity.
Well, hold on. If he found it was a legal nullity, then he could not consider any other question in the case. If an action is a legal nullity, then the court is bound by judicial constraint not to consider any other questions in the matter.
Your Honor, may I respond to the question? I see my time's up. I just want to make sure.
You can respond to his question.
Thank you. The difference, though, is we have the same judge in both the foreclosure action and the quiet title action. So essentially, putting aside what he did in the foreclosure action, he essentially clarified his decision. He essentially checked the box for FAPA. Again, we submitted cannot apply retroactively, but he essentially checked the box from FAPA and said, yes, my prior decision on the foreclosure was because it was a legal nullity and therefore acceleration didn't happen.
Do you have any further questions? Thank you very much.
Thank you.
Judges, respectfully, Judge Thompson, the Supreme Court did not check any boxes regarding FAPA because FAPA was not in effect at the time that Judge Thompson made the decision. FAPA came into effect December 30th, 2022, and that's what is one of the subjects of this appeal. Regarding FAPA, it is, as Judge Kern noted, it's supposed to look at the prior action, that is the 2009 action, and see, did the defendant make an interposed defense, a timely interposed defense, that there was, that the statute of limitations had expired? And if they make that defense, did the judge rule on that exact thing? That's what FAPA states. That's the plain language of the statute. And if that did not occur, then the respondent in a 1501 action cannot assert the defense of that there's been no expiration of the statute of limitations.
Well, as I understood your friend's argument, how would a party have known and a judge have known in 2009 to raise that particular issue?
It's not the judge's place to raise the issue, Your Honor.
But how would a party know to raise that issue and preserve the defense?
Sure. So when you're responding to a foreclosure complaint, you're going to list your entire, list or laundry list of defenses. And one of those defenses would be that the statute of limitations expired. And whether a jurisdictional issue came up first or that statute of limitations came up, then they would be able to address it. Interestingly enough, Judge Higgett, what happened below was that the estate did not answer. There was a default on behalf of the estate, and that when you look at the history of this action, it's kind of insane and fascinating at the same time, but there was an order of reference in 2014, again occurred later, so there was, in that lower case that we eventually got vacated, there was a foreclosure of judgment and sale which we vacated and had to vacate after we filed an appeal, and then it was granted upon a motion to restore. So we went all the way down the chain with the respondent nation, or Wells Fargo at that point, asserting that it had been accelerated. I'm sorry, judges.
Yeah, and I gave you extra time because I forgot to set the clock, so thank you.
Okay, thank you, judges. Have a wonderful day. Thank you.
Thank you.
People versus Murta.
Good afternoon, Your Honors. My name is Christina Schwartz, and I represent the appellant, Philip Murtha. We are asking this court to reduce Mr. Murtha's sentence from 7 years to 6 years. I'm
Counsel,
sure.
didn't we already get the near minimum sentence in this case? I mean, the maximum was 15, the minimum was 6, and he got 7. So he got pretty close to the minimum in this case, right?
Well, that's true, but
So why should we interfere in this case where he got already very close to the minimum?
well, it is in your power and right to
No, it's not
review it.
power, but why should we do it?
And I believe it's appropriate for a number of reasons. First of all, as you pointed out, the minimum
And he
is-
was sentenced concurrently. He got near the minimum sentence and he got a concurrent sentence. So he got a generous
right.
resolution.
I understand that, but I want the court to be aware that he was sentenced, he was subject to enhanced sentencing terms because his prior conviction, which happened when he was a teenager, was a violent. So if it had been a nonviolent, the minimum would have been 2 years. So the fact that he got sent the minimum 6, the legislature has already taken into account, his prior history, and it's many more years than if it had been a nonviolent. So 7 years, is in 6 years. It's just it's already been taken into account, and then because he pled guilty before any hearing and trial, and because he accepted responsibility for the crime, those are reasons to normally receive the minimum sentence, and in this case, a minimum sentence would have been appropriate. He had a small child at the time, who's now 6 years old, and
So counsel,
the
counsel, this defendant has 2 prior felony convictions. He was on parole at the time that he committed these 2 offenses, each one of them a felony. He committed the offenses 1 month from each other. So he gets arrested in December for one offense, he gets arrested in January for another offense. Not even a month apart. I think about.
But sentencing him to an additional year
And
over
he
the minimum
negotiates
for
a
being
deal. He
misguided.
negotiates a deal with the court, and he gets close to the minimum. Why should we disturb that?
Well, again, enhancing his sentence from the minimum, which would be
1 year?
typical.
By 1 year?
By 1 year.
Given his record and given the fact that it's 2 additional felonies.
And a year is an enormous amount of time. It's an enormous amount of time. It's even larger with a young child at home. And to understand that he said repeatedly that his reason for doing this was, the misguided reason for
Make
sure,
money.
was to make money.
To make money.
And,
So he's selling in the street. He gets caught with drugs. He gets caught with money because that's his business. He does it basically less than a month apart. He already has a felony record, a violent record at that. The court gives him 1 year above the minimum, and you want us a negotiated plea, and you want us to disturb that deal that he got with the people in the court for 1 year above the minimum.
well, there's one other factor that I'd like the court to be made aware of, which is
No,
that
I'm going to let you
because of
I'm gonna
his
let you make aware of it
predicate-
in rebuttal. I'm going to let us know that in rebuttal.
Of course.
Good afternoon, Your Honors. May it please the court. Jennifer Mitchell for the people. Defendant's excessive sentence claim is foreclosed by his valid waiver of appeal, and in any event, his bargained for sentence was fair and appropriate and should not be disturbed. While defendant was on parole for an unrelated conviction, he was found with a substantial quantity of crack cocaine on him on 2 separate occasions that occurred within 1 month of each other. Defendant was facing 4 felony charges, yet only had to plead to 2 counts of third-degree criminal possession of a controlled substance in exchange for the very lenient sentence that he received. And although his sentences could have run consecutively, he received the additional benefit of having those sentences run concurrently. Just 1 count alone carried a maximum sentence of 15 years. For the 2 counts that defendant pled to, he faced an aggregate sentence of 30 years. Instead, defendant received a sentence only 1 year above the statutory minimum and 3 years lower than the people's recommendation. All of defendant's purported mitigating factors were fully considered by the sentencing judge below and do not warrant a further reduction in this case. Therefore, this court should not reduce defendant's sentence, and if there are no questions, then the people ask that you affirm.
Thank you very much.
I wanted to make sure the court was aware of one last thing, which is that because he had additional parole time, he actually is serving more than 7 years, in close to 8 years, and actual years, not with the good time. So he's facing 7 years, 10 months, and 14 days. And so at the time that they were negotiating this plea, I think it's likely that they were considering that he would be subject to good time. But instead, he's getting more time than was anticipated. And again, thinking to what's best for society, what's best for him, his young child. He has family that have been in contact with our office constantly, that care about him and want to help him and make sure that he has a legitimate job on release. A year is an enormous amount of time to a young man like this who will be in his 30s when he gets released, whether you grant this reduction or not.
Thank you.
Very different point of view. Thank you very much.
Board of Managers 15 versus BCRE 15.
Good afternoon, Your Honors. Joaquin Escuder of Morrison Cohen for appellants. Your Honors, this is a breach of contract case. The complaint states in its first paragraph, the Association of Unit Owners, now free of the sponsor's control, sues for breach of contract and fraud in the offering plan. The entire complaint is replete with allegations of misrepresentations in the offering plan and of construction conducted in contravention of representations made in the offering plan. The sole issue on this appeal is whether, in light of the nature of this case, an unjust enrichment claim against the appellants may be maintained.
And that's the only remaining claim against these defendants, correct?
Correct, Your Honor. Yes. And the extensive case law and precedent of this court suggests that it cannot, and that the lower court erred in failing to dismiss that claim against the appellants. We've cited all the cases in our briefs. We'll rest on those cases. I'd note that the respondent cited no appellant-level cases in contravention of the well-established principle that you cannot have an unjust enrichment claim where there is an agreement that governs the subject matter of the claim, which is the case here, and that is true even where the unjust enrichment claim is asserted against non-signatories to the agreement.
And so why should that be?
Sorry, why should the...
Why should that be the rule? Your clients are signatories to the offering plan, correct?
Correct, they're not signatories.
So plaintiff has no breach of contract against you. So to the extent he has any cognizable claims, they would have to sound in quasi-contract or some other, in a tort. There's no possibility from where your clients stand of there being a duplicative breach of contract and unjust enrichment action. So why should a contract governing the rights of other parties dictate whether a quasi-contractual remedy lies against a non-party to the contract?
Well, I mean, there might be circumstances in which that is the case, but that is definitely not the case here. Number one is when you look at the unjust enrichment claim here, it specifically says the sponsor defendant should not be permitted in equity and good conscience to breach their contractual obligations under the terms of the offering plan. That is from the unjust enrichment claim. And it also seeks the exact same damages that the breach of contract claim seeks. So in fact, here it is duplicative, and that principle should be upheld here. There is no reason to deviate from that principle. So the other basis for dismissing, which the lower court should have dismissed the claim, was law of the case doctrine. Again, we have the same exact
You can't
claim.
argue law of the case to us because we're the appellate division, so it doesn't apply to us, so.
Understood. I'm just saying, yes, that's the basis
Right,
in
but
which
for
they
us,
should
it
have.
wouldn't apply.
Okay, understood. And then the last issue is that the respondent has inserted in their brief a request for leave to amend. That should be denied for the reasons that it would be futile to allege any kind of unjust enrichment claim against the appellants under this circumstance. And
Is that relief sought below?
I'm sorry?
Was that relief sought below?
It was sought, but not properly. They did not actually cross-move for that relief. They kind of inserted it into their brief as an afterthought. So we urge that the panel adhere to its prior precedent, which is extensive, and modify the lower court's decision and dismiss the unjust enrichment claim. Thank you.
Thank you.
May it please the court, my name is David Berkey, Galatrier and Berkey, counsel for plaintiff respondent,
So,
Board of
counsel,
Managers.
why shouldn't we follow our extensive precedent, which does hold that when there's a breach of contract claim, you can't assert a quasi-contractual claim even to the non-signatories to the contract? Why shouldn't that principle, which has been articulated a number of times, be applied in this case?
Your Honor, there are two critical reasons why on this appeal, that line of cases should not be followed. The first is technical. The contract was never submitted to the court below. There was no showing by the defendants that they were governed by the terms of the supposed contract,
But
which is in the offering
whether or
plan.
not they're covered, that's not really what the principle is dependent on. First of all, your pleadings keep referring to the contract to form the basis of the courses of action, but this principle is not based on the contract, including non-signatories. It's based on what you, the plaintiff's claim is. If your claim consists of a breach of contract claim primarily, you can't then assert typically an unjust enrichment for those same allegations. So what about the unjust enrichment is different than the breach of contract in this case, other than that it's non-signatories?
Your Honor, I agree with you that the court below in its earlier decision properly dismissed the unjust enrichment claim against the sponsor because it was duplicative of the breach of contract claim against the sponsor. But with respect to the other defendants who are appellants here, the complaint has a plethora of allegations about them wearing different hats, being in charge of the board of managers of the condominium, being in charge of different LLC entities that were created.
What have they done? What are you alleging they have done that's distinct from breaching the terms of the contract? What wrong have they committed?
Your Honor, the basis is they took the money that was paid by the unit owners to purchase their apartments, and they put it in their pockets and in the pockets of the entities that they controlled, not the sponsor, so that the sponsor would have money and be subject to collection if we prevail on the breach of contract.
Normally, if
they
you
diverted it.
want to go, I mean, this is not really articulated in the case law, but if you want to go a parent against a parent or an affiliate or some related entity, you have to establish a piercing the corporate veil or something more, as opposed to an unjust enrichment cause of action.
But isn't all of this about the offering plan?
Yes.
Isn't all of it about the offering plan?
The individual conduct of the sponsor affiliates is not a part of the contractual obligation in the offering plan, which is to build the building in accordance with the plans and specs and in accordance with usual construction practices. What they did is because they put themselves in a role where they were in control of all the entities, including the condominium, is they diverted the proceeds of sale. They put it in their pocket. They created entities that they paid, which they also received the benefits from. And so what we're saying here is, you know, they took advantage of their position and their multiple hats that they were wearing to take the money that should have been left in the sponsor's coffers so that the breach of contract claim could have been successful. And that's what Deborah James found, Justice James found. She went through the complaint and she said that it's full of allegations of improper conduct, unjust enrichment on behalf of the sponsor affiliates. So that's why she found that the claim
Sir,
against them should lie.
aren't all those allegations tethered to the contractual obligations under the offering plan?
Not precisely, Your Honor. The contractual obligations say you have to build a building and deliver it in accordance with the plans and specs. The allegations against them are that they managed a half a dozen entities as well as controlled the board so that they were able to take the money and unjustly enrich themselves rather than leave the money so that the unit owners could collect it from the sponsor.
Thank you very much.
Your Honors, just very briefly, at the risk of being repetitive, this is paragraph 159 of the complaint. And by the way, the complaint lumps the appellants here with the sponsor defendant, the one who's subject to the breach of contract claim, as the sponsor defendant. So this unjust enrichment claim was asserted against everybody and says the sponsor defendant should not be permitted, in equity and good conscience, to breach their contractual obligations under the terms of the offering plan and thereby to obtain for themselves the windfall benefits of the conversion of the building to condominium ownership and the sale of the condominium units to the unit owners at the high prices specified in the offering plan. The very language of the complaint states that this is all about the offering plan. We respectfully submit that the precedent suggests that this unjust enrichment claim cannot be maintained. Thank you.
Thank you. Hoag versus Board of Education.
I apologize.
Okay.
If it may please the court, Jimmy Wagner for the appellant. Good afternoon, Your Honors. I would like to focus on 3 violations of the law by the respondents in this manner. The first violation of the law, as evidenced by the record, is that they applied the wrong undue hardship standard when denying the appellant his religious accommodation. The undue hardship standard to be applied should have been significant. They admit in the record they applied the lower federal standard of de minimis. They acknowledge they routinely applied the lower standard of de minimis. New York State and New York City have never enjoyed and never took place with the de minimis standard that was in the federal law. We have always been an undue hardship must be a significant burden. The second,
Counsel, would you say anyway, whatever the standard, whether it's city human rights law or
New York State human rights law,
why shouldn't we defer to the respondent's determination that teaching in person is very important and teaching remotely is not a substitute?
Well, there's 2 issues in that question, Your Honor. And again, it's a violation of the law. The record never supports a finding that teaching in person couldn't have been done. It's absent from the record. What's in the record is a hearsay statement. The position statement is undated, unsigned hearsay created explicitly for the litigation. We have no idea if the citywide appeal panel ever viewed that position statement. In fact, the position statement, if we actually analyze the position statement, it conflicts with the record. Because the position statement, and that would be The position statement that we're referring to is in the record, page 205. If we look at this position statement, and we go to, in the record, page 206, that's the second page of the position statement. If we look at the Eichenholz affidavit, what he says is every time the citywide appeal panel reviewed an appeal accommodation, they had weekly meetings to update what was going on with all the accommodations that were granted. But this position statement says more than 3,300 DOE people applied, and there were a limited number of people who could obtain that accommodation. If this was provided to the citywide appeal panel at the time they were hearing the appeal, they would never have been able to know that there was 3,300 people that had been applied and how many were granted or denied, as alleged in this position statement, because the appellant's position statement, his application was denied in March. We know, I can affirm to this court, after March, there was still appeals from the citywide appeal panel going forward. So how would the citywide appeal panel, if they had this document at the time they denied appellant, know the numbers they needed to meet their thresholds? Because if we move through this position statement again, which the court shouldn't consider, it is inadmissible hearsay, but it's discriminatory on its face. Page 207, the last page of this position statement states, to be sure, there may be a small number of special cases warranting a different approach, but as a general matter, this is an undue hardship that has been shown on the ground and only will grow with each exemption granted. To be sure, there's a small number of special cases. Let's hypothetically talk about this small number of special cases. If that small number of special cases was Catholics and only Catholics were granted that exemption, that'd be discrimination. If it was a small number of special cases that was only white men that were granted the exemption, it would be discrimination.
Counsel,
What is
I'm sorry, I lost a thread there. What's the point of this hypothetical?
The hypothetical stating in the position statement, it says there's a small number of special cases.
You said that, but...
So the well, Judge, you can't have a small number there's no special people under New York City human rights law. The undue hardship burden was the respondents had to prove undue hardship. This record is absent of any proof that they even attempted to prove undue hardship. What they said was the only available accommodation was remote teaching, and everyone gets denied, except this small number of special cases.
But that's driven by student need, right? I mean, isn't that clear?
Well, no, we would look to New York City human rights, which defines undue hardship for us. So what's the cooperative dialogue process? The cooperative dialogue process, as distinguished by this court in Phillips, is we have to look to the appellant's accommodation needs. We have to look at potential accommodations of the appellant. We have to look at all the world of potential accommodations that exist.
I'm going to let you continue, unless you have more questions.
it's okay.
I'll
I'll
let
let
you
them
continue
go.
that in rebuttal.
May it please the court, Rebecca Viscatas for the city respondents. Your Honors, the record demonstrates that DOE and the citywide panel had a rational basis to deny Hoag's accommodation request. In its initial determination, DOE explained that regardless of whether he had sincerely held religious beliefs that precluded vaccination, granting an accommodation would present an undue hardship. The denial letter itself that he received explained that unvaccinated employees could not work on site anywhere where they would have contact with students, staff, or families, because that would pose a direct threat to public safety.
Excuse me, I'd just like to stop you there for a second, because obviously our review is very narrow here, and one of the grounds we could disturb the administrative determination is if the proceeding was infected by an error of law. Is your friend correct that the citywide panel was employing the wrong standard of de minimis?
No, Your Honor. While the initial letter did reference the fact that this would have presented more than a minimal burden, that did not reflect the full analysis that DOE clearly applied. The position statement that was properly introduced into evidence that the context in the record demonstrates was submitted to the citywide panel, just as in the numerous other appeals that this court is hearing with similar position statements, shows that DOE thoroughly analyzed the effect that that this requested accommodation of teaching remotely would have on its operational and monetary costs. It analyzed the identifiable costs of providing that accommodation, especially in light of the number of people who might need such an accommodation, which are exactly the factors that are laid out by the city human rights law. So the reference to more than a minimal burden, which was the widely recognized federal standard at the time based on years of case law, does not indicate that that was the only thing that DOE was looking at. In addition, the citywide panel, as the Eichenholz affirmation that is in evidence explicitly states, was considering specifically city, state, and federal level guidance and all relevant laws in considering both the undue hardship part of this analysis as well as the sincerely held religious beliefs part of the analysis. So I think there's no question that DOE and the citywide panel were applying the correct standard.
Was there a cooperative dialogue?
There was, in particular under this court's recent holding in Marsteller, in which the process was essentially identical. And in that decision, this court specifically held that, especially under the circumstances at the time in which the city was receiving thousands of nearly identical accommodation requests and had to handle all of these in an expeditious manner, and especially in DOE cases where school was starting and children needed people to teach them in a matter of days or weeks. The process that was in place here was sufficient. That Mr. Hogue he received the letter from DOE, he received the information about how to appeal first to an independent arbitrator under the procedures in place at the time under the arbitration award, and then to the citywide panel. He availed himself of that process. He provided more information about his religious beliefs to the citywide panel, and that back and forth was sufficient, in particular under this court's recent holding.
Were there any applicants for the exemption that got granted the exemption?
That information is not in the record. I mean, I can tell you as background knowledge that as the DOE position statement indicates, there were a small number of people who may have warranted a different response. There were perhaps some teachers who had already been in a unique situation before the pandemic, and so perhaps upon further review, those teachers may not, their accommodation may not have presented an undue hardship. Again, that information is not in the record, and what ultimately is at issue here is the denial of the accommodation for this petitioner, who is a classroom teacher, something he does not dispute. He did not teach remotely until the pandemic, which was obviously a unique situation in which teachers and students were at home, and that situation was no longer presented in the fall of 2021 when, in order to most effectively educate its students, DOE determined that students should return in person.
Is the last sentence of the position statement on its face susceptible of some sort of discriminatory meaning or import?
Absolutely not. That is complete speculation. I think that a much more obvious reading of that is, as I said, that there were some teachers who may have had particular circumstances based on their position and their role within DOE that might have allowed them to work remotely, even though most employees, in particular classroom teachers like Hogue, could not do that feasibly.
Thank you very much.
Thank you.
Justice Higgett, this is the exact reason why this position statement is inadmissible hearsay. Because we're sitting here, we have no idea who authored this, we have no idea when it was created, and we have no idea what the meaning behind it was. So we as attorneys in this court shouldn't have to guess. This document, counter to what counsel said, was never admitted into evidence. The lower court decision explicitly states over my objections, the lower court considered it. This was a pre-answer motion. So if we're to use the standard of a pre-answer motion, everything should have been viewed in a light most favorable to the appellant. Instead, what the lower court did was issue its entire decision based on this undated, unsigned hearsay document. And if we look at the record, Mr. Eichenholz does acknowledge what standard he used, and that's record page 179, paragraph 32. He states they used the lower federal standard of de minimis, not the New York State and the New York City higher standard.
Thank you very much. Thank
Your
you.
Honor, and-
No, thank you.
Well, I had submitted a letter.
No,
requesting
thank you.
more
Your
time,
time's up.
and I was denied. And
Well, your time is the time I gave you. Thank you very much. Thank you. The next case is People versus Norwood.
May it please the court, Svetlana Kornfeind for appellant William Norwood. The court can and should reduce Mr. Norwood's sentence. The totality of the circumstances does not support a determination that the waiver of appeal was knowing and voluntary. The court's waiver colloquy was inconsistent even within itself and with the written waiver. And the court also conflated the waiver of the right to trial with the waiver of the right to an appeal. And this, of course, the court completely cannot have confidence that Mr. Norwood, who does not have a college education, whose prior felony conviction was 25 years earlier and who was convicted after trial, it would have no reason to understand the waiver, especially listening to the court and getting this confusion. The court should reduce his sentence because of the sentencing factors: rehabilitation, deterrence, punishment, and acceptance of responsibility. He's accepted responsibility. Should note he accepted responsibility in the probation interview when he
Counsel, it's possible to be empathetic with the defendant's history, his mental health history, but did he specify at any point that he would participate in programs to address that? And did he advocate for himself in that way?
He did. He tried to. Like, as you know, he had a mental health and substance abuse history since he was a child, 12 years old. Despite that, he worked for 30 years, and he tried to. He went in and out of programs, and I submit that the programs failed him. So he's aware of his problem, and he tried to help himself. And because he has this work history, and he did accept responsibility, he's someone for whom rehabilitation is a positive factor and that should be considered by the court. In terms of deterrence, he's 61 years old. I mean, statistically speaking, and even looking at his history, he is at a very, very low risk of recidivism. So the deterrence checkbox is checked off. That box is checked off. And in terms of...
He was already 53 at the time of the offense, right?
Yes, he was. And the earlier felony conviction was 25 years earlier. And in between then, he did have this work history. He tried to take care of himself. This incident, which is very serious, he was under the influence of crack cocaine.
You'll have time on rebuttal to finish up.
Thank you.
Thank you.
May it please the court, Assistant District Attorney Saad Siddiqui on behalf of the respondent people of the state of New York. Your Honor, the defendant's execution of his waiver of his right to appeal was knowing, voluntary, intelligent, and precludes any review by this court of the excessiveness of his sentence. And more to the point, substantively, the defendant's 12-year sentence for setting a woman's hands and face on fire after spraying her with lighter fluid was especially fair in light of his prior criminal history, which the trial court, the plea court, Judge Iacovetta, was more than aware of, the underlying facts of the case, and the fact that the trial court had already taken all of this into consideration. The original offer, the original sentence the people were seeking was 20 years incarceration, and the court reduced it from 20 years to 12 years. The plea colloquy was very clear and extensive. The record completely supports that there was a clear separation between defendant waiving his trial rights and his waiver of his right to appeal. For the foregoing reasons, we ask that the court affirm the defendant's sentence, and we rely on our submissions. And unless the court has any other questions, thank you.
Thank you very much.
First, briefly on the waiver. At the end, when the court was summarizing the rights that Mr. Norwood was giving up, the court said, except for the items mentioned in the written waiver, you're waiving all other avenues of appealing your conviction. Do you understand that? Yes. That includes the following. You can't appeal your sentence to a higher court and argue it should be reduced or lowered because it's too long. Do you understand that? Yes. And you're also waiving your right to a trial. And you're also waiving your right to a hearing to suppress evidence. That's a conflation. He's mingling them together, and this came at the end as a summary. This is the last thought from the judge on the waiver that was in Mr. Norwood's mind. In terms of the sentence reduction, he's now 61. He's been in prison for more than 8 years. And I submit, in terms of the sentencing factors, the rehabilitation, deterrence, punishment, and acceptance of responsibility, that he's more than satisfied that. Thank you.
Thank you very much. Bick versus Bick.
Good afternoon, Your Honors. James Masella from the law firm Ballard Spahr for appellants, defendants Gonzalez Charles and Guillaume Bick. The court below granted partial summary judgment in favor of the plaintiff, Veronique Bick, who is the biological mother of the 3 defendants. Summary judgment should not have been granted here, Your Honors, in favor of Ms. Bick because it's axiomatic that under New York law, a plaintiff suing for a breach of contract must demonstrate her own performance of that contract. Here, Ms. Bick admits that she did not perform the contract. Instead, she argues that under the marital agreement, there is a notice and cure provision. And Ms. Bick claims that that notice and cure provision
Can we talk about the Grenville debt for a moment?
I'm sorry?
The Grenville debt.
Of course.
So that was paid down, I take it, from dividends that were thrown off.
That is not correct, Your Honor.
How was that paid down? Because it was initially 7 mil euros, and then it went down to 1 mil euros and change. How did that happen?
The amount that it went down to, I believe, is an issue in dispute.
Okay,
And
it went down. So how did it go down?
The payment came out of Mr. Bick's pockets from his personal resources.
It wasn't paid from dividends.
It is my understanding that it was not paid by the dividends of stock that were held by the Grinnell entity itself.
Okay.
And Grinnell entity holds 400,000 Bick shares and does regularly receive dividends.
If the obligation to pay down the Grenville debt arose immediately upon the signing of the post-nup, why didn't anybody beef about her not paying it?
Because under paragraph 19, it was not actionable, meaning until an operative event happened, although the transfer happened within 30 days of the agreement being signed, that was not enforceable until there was an operative event. And the operative event happened a year later, so that did not happen until August of 2017.
Please continue.
Thank you, Your Honor. Ms. Bick, Ms. Bick, as I mentioned, points to the notice and cure provision and claims that she did not receive notice or cure, and that did not receive that opportunity.
Aside, though,
Certainly.
isn't the language of agreement indicate that the obligation to pay, to give the Grinnell interest and the Bick shares within 30 days of the operative event is unconditional, that is going to occur within 30 days of the operative event? I mean, there's pretty strong language that supports that interpretation in the agreement itself, that the intent of the agreement was to split the assets 50-50, and it says pretty unambiguously, the wife shall receive the interest in Grinnell, which shall be transferred to her within 30 days of the execution of the agreement. There's no room for interpretation when you listen to those terms.
Respectfully, Your Honor, I do not believe that's true under the applicable rules of construction. I believe, and we outlined this at length in our brief, that within 30 days of the execution of the agreement, Ms. Bick became responsible for the debt, but she did not have entitlement to receive.
We're still not even sure what the amount of the debt is. So why isn't it a reasonable construction that these two things, which are determinable, that she shall receive the big share, she shall receive the Grinnell interest, why shouldn't that happen independent of the other obligations, and then within the context of, which is not really a matrimonial proceeding anymore, but the proceeding all be determined how to shift the other amounts around that? What was incorrect in the court below coming to that determination?
So the amount of the debt was set at the time the agreement was executed.
Well, that's disputed. That's one of the major disputes in the case, whether or not the Grinnell debt should be calculated as of the time the agreement was executed, whether it should be calculated as of the time of the operative event, or whether it's ambiguous, and we can't make that determination yet.
And that's why our fallback position, Your Honor, is that the judge's determination in this respect should be vacated, and it should be a matter presented for trial.
Right, so even if the amount of the Grinnell debt should be subject to trial, even if we haven't discussed it yet, even if we agree that it's ambiguous, why shouldn't she get summary judgment with respect to the transfer of the Grinnell interest in the big shares? Why shouldn't that happen independently of the other obligations?
Well, so here, the contract itself sets up a scheme, and that scheme provides that she will have entitlement to the exclusive use and occupancy of Grinnell LLC within 30 days after the date of an operative event. And that's also the same time that these obligations become applicable, meaning the debt transfers within 30 days.
But we don't know the answer yet. We don't know the answer yet when the Grinnell debt is due. We're going to either have a trial that's ambiguous or, I mean, we haven't determined that yet, but why can't they be separated? This is the question.
I'm sorry, Your Honor. Why can't?
Why can't the issue of how much she owes on the debt be separated from the issue of which is what you're challenging. You're challenging that the court said that we're going to decide right now that the Grinnell interest be turned over in the big shares. Why can't that be decided separately from the issue of the amount of the Grinnell debt?
The provision itself is rife with vagueness, and there are factual disputes that arise out of that. I think that either the amount was set within 30 days of the agreement being signed, and therefore that's the amount that's applicable and those obligations are applicable, or the whole thing should be decided at trial.
Okay, let me hear from opposing counsel.
Thank you, Your Honors.
May it please the court, my name is Michael Bowen. I'm the counsel on behalf of Veronique Bick, who's the plaintiff, respondent, and cross-appellant. Justice Kern's point about separating out enforcement of the rights is exactly correct, and it's actually written into the marital agreement, which is section 46, which states specifically that every right and obligation under this agreement can be enforced.
Right. So much depends on paragraph 46 for you. But they say you didn't raise paragraph 46 below.
Oh, we did, Your Honor. It's in the record below. We did raise section 46. It's a key point in the contract. In fact, I believe it's even raised in the complaint. And going back to Justice Kern's point, the idea is that there are clear rights where the husband had to give 50% of the Bick shares and Grinnell, 98% interest in Grinnell, which holds Bick shares, and that was part of the calculation to get to Veronique Bick, her 50% of the family Bick shares. So it's critical that those rights be enforced separately. Now, the other issue is that under that contract, under section 36, in order for either party to enforce any right, they have to give written notice and a demand for cure before they can sue. The only party here, even to this day, who provided written notice and demand for cure was Veronique. And she did it in this 2 months before this action.
Doesn't that requirement have to do with filing a lawsuit, that you have to give the notice before you file a lawsuit? But your client is the one who filed the lawsuit. So why is their notice provisions?
Because if they're going to enforce a separate issue under that contract, they have to give notice first
But
and time
the
to
notice
cure.
talks about filing a lawsuit. It doesn't talk about making a claim.
Well, it says you can only file a lawsuit to enforce any aspect of that
You
agreement.
filed a lawsuit. He didn't file the lawsuit.
Well, he filed counterclaims, and in order for him to file the counterclaims, he would have to have given notice and a demand for cure first.
That's your argument. Let me ask you about the Grinnell debt. The court below said it's unambiguous, but aren't there within the agreement itself contradictory terms about what happens? Isn't there one portion which clearly says the Grinnell debt will be paid at the time of the execution agreement, and then there's other contradictory language which supports your position? So why was it correct for the court to make a determination as a matter of law that the Grinnell debt should be determined at the time of the operative agreement rather than at the time of execution? How can we decide that either way as a matter of law?
Well, because of the structure of that clause, which is 19F. And what that clause says is that the wife, Ms. Bick, shall receive the 98% interest, and it shall be transferred, meaning the 98% Grinnell interest shall be transferred within 30 days of executing the agreement. The parallel structure of those two terms indicates that both of those clauses are referring to the Grinnell interest. There is no clause that says that she's obligated to pay the debt starting at the time that she signed the contract. And that wouldn't make sense because the only way she could pay the debt was with marital funds. She jointly owned all of the funds, all of the property. So if she was paying down that debt, she would have done the same thing Mr. Bick did, which was paying the debt down either from the Grinnell money itself, which, by the way, is in the record. The only thing in the record about that, which is at A454 through 474 and A411, that's the evidence that the Grinnell debt was being paid from the dividends from the Bick shares held by Grinnell.
Sir, is there any tension between your position and paragraph 23?
No, there isn't.
Paragraph 23 distinguishes between the lifestyle debt on the one hand and the Grinnell debt on the other, and says the lifestyle debt, it won't be until an operative event occurs will the debt be transferred there, yet it doesn't distinguish the Grinnell debt in that fashion in the very next sentence. It just says the wife shall be solely responsible for the payment of the Grinnell debt.
But that clause has no effect until the operative event, which is paragraph 16 of the record, of the marital agreement, which says that you have to have the operative event before paragraph 23 has any effect or meaning whatsoever. And the language in paragraph 23, again, parallels the language in 19F, because the language that says that the lifestyle debt shall be divided evenly as of the language is, what's the language? I've been looking at this all day.
Which paragraph?
Then outstanding at the time of occurrence of an operative event?
Yes, thank you. Then outstanding, that's one of the key languages. Then outstanding at the time of the operative event. That language is in 19F referring to the Grinnell debt, and that language is also in paragraph 23 referring to the lifestyle debt. So both
Then
of those
why
phrases,
point it out in 23 for the lifestyle debt but not the Grinnell debt?
because in paragraph 23, she becomes responsible for the entirety of that debt as of the time of the operative event. And that's the difference in language. So on the one hand, they're saying they split it 50-50 with the lifestyle debt, but as of for the Grinnell debt, she's responsible for that entirely. And in fact, if the lender is still going after Mr. Bick after the operative event, she then has to indemnify him. And that all makes sense in the context of dividing up marital property as of the time that the parties are separating their two estates.
And you'll have time for rebuttal.
Thank you.
Thank you, Your Honors. Let me just address some of those points very briefly. First of all, this appeal is the very first time that Veronique Bick has ever raised paragraph 46. That's why there's no mention of paragraph 46 in the decision below. That's why there's no mention in the record on appeal. The only mention of paragraph 46 is in the agreement itself, and that has never been previously raised. And that's probably because Veronique Bick argued in the court below that Bruno Bick breached first, so her performance should be excused, which is a perfectly fine strategic choice for one to make, but that's the strategic choice that was made. That argument has been waived. Now, with respect to with respect to the Grinnell debt, I think that there are two distinct branches that one could go that are appropriate here. One is either the court's decision should be vacated because there are genuine issues of factual dispute concerning these issues. The language is confused, vague, and contradictory. Thank you very much, Your Honors.
Thank you.
Even in their own opposition brief to our first appellant or respondent brief, the appellant admits in their brief that we cited Section 46 below. And I was looking for the page, I didn't find it, but I will try and find it as I'm addressing the other issues. I did want to say that we did cross appeal. There was a determination by Justice Leibovitz below that a fiduciary duty claim had been established, but that fiduciary duty claim relies on a contract provision, Section 24, about return of property, which is actually not a very clear reading of that section, but that's the only standard that the appellant was pointing to below, the defendant. So that cannot support a fiduciary duty claim. The other argument was that she damaged some art that belongs to the deceased, and because of that, she violated some fiduciary duty, but there's no evidence that she caused any damage. In fact, there's no admissible evidence.
Isn't there at least an issue of tribal fact on that question, though? Because there was, I mean, no one disputes that some of the artwork was degraded in some way or another.
Well, actually, there's no evidence of that at all. The issue, what the judge gave summary judgment in favor of the defendant, saying that the plaintiff had breached her fiduciary duty because the art had been damaged. We're just asking that that determination be reversed. It would be tried to the finder of fact below about whether there is, in fact, any evidence showing that she was the cause of any damage, or A, whether any damage actually exists, and B, whether she was the cause of it. Our argument is based on the record.
Thank you very much.
Thank you.
Thank you very much.
Smith Gambrell versus 3 West 16th.
May it please the court, my name is John McCarthy. I'm with the law firm of Smith, Gambrell, and Russell LLP, representing the law firm of Smith, Gambrell, and Russell LLP, plaintiff appellant. The trial court's order that's subject to review erroneously granted the defendant's 3211A5 motion for both substantive and procedurally erroneous reasons. In addition, it dismissed the entire complaint without addressing 2 equitable claims. And finally, it was in error when it declined to consider the plaintiff's summary judgment motion. First, I'll address.
Why shouldn't we just treat defendant's motion to dismiss as the summary judgment motion?
I'm sorry.
Why shouldn't we just treat defendant's motion to dismiss as a summary judgment motion?
Because, Your Honor, the CPLR is clear that before that happens, the court below was required to give us specific notice that it was planning to do that, and it did not do that here. In addition, Your Honor, I would point out that in our reply brief, we noted all the factual issues that were in the record on our motion for summary judgment that demonstrate that there are factual questions about the factual issues with respect to some of the issues that they raised on their motion to dismiss. But this court's precedent with respect to the procedural issue is that once an answer has been filed, you no longer can proceed under 3211, you have to proceed under 3212. The court, that's not what they moved under. The court didn't give us notice, and therefore it's defective, and we should at least go back down on the procedural issue. But we think the substantive issue can also be addressed, Your Honors, and that is—
If we accept your procedural argument, then we shouldn't get to the substantive argument, right?
I suppose that's true, Your Honor.
We should just remand it for the court to decide the summary judgment motion, make a determination, then there'll be a record if it needs to be appealed, what the court would actually do in the summary judgment motion. Is that correct?
Well, I think Your Honors can also look at the record and decide the motion substantively, because as a substantive matter under 3211, their motion is also should have been denied, because we're governed by the General Obligations Law 17101, which says that if there's an acknowledgement in a writing signed by the party, and the case law says if that acknowledgement, if the writing recognizes an existing debt and contains nothing inconsistent with an intention to pay, the statute of limitations is revived. And that was what the motion to dismiss was based on, statute of limitations.
But who was that acknowledgement submitted to?
It was first, Your Honor, respectfully, that's not relevant because there's no case law. That's not what the standard is, but it was, to answer your question, it was filed publicly in a bankruptcy proceeding in which our firm had filed an appearance on behalf of the defendant. So it was a publicly filed document, not too much dissimilar to all the cases we cited in our reply brief.
They are alleging that somehow your office had something to do with that acknowledgement being filed in the bankruptcy court.
Well, Your Honor, that's outside of the complaint. That's, you know, that's a factual issue. I would also say it's not true. The evidence that was in the record on our motion shows that it was the defendants who asked for all the bills so that all of our legal fees could be included in the proof of claim. We referenced that in our reply brief, Your Honor.
What evidence did you hold back putting in opposition to the 3211 motion because it hadn't been styled as summary judgment motion?
Well, Your Honor, one thing is the fact that our firm was continuing to receive notices of everything that was publicly filed in the bankruptcy case, and that as well as the subsequent counsel for the defendant, and that the notices indicated that we were getting notice of everything, including the filing of the proof of claim that acknowledged the debt. And then there was, as alleged in the complaint and shown in our motion for summary judgment, there was a subsequent request by the defendant less than 2 months after the acknowledgement through the proof of claim that they were requesting that we table the issue until later in the bankruptcy case. So the trial court here on the acknowledgement of debt, so that's the answer to the question of about at least one piece of evidence that would be.
So there were potentially material items relevant to the statute of limitation questions that you could have pursued in discovery.
Correct, Your Honor. Neither the trial court nor the respondents have cited any cases to support the trial court's determination that the reason that the debt wasn't acknowledged and the statute restarted was because it was unrelated to us and because they subsequently sued for malpractice. No authority cited by either the trial court or the respondent in their brief on that point. We'd also point Your Honors out to Meyerowitz Estate, which involved a situation where the court found that the statute of limitations were revived when the debtor had signed corporate tax returns showing the debts were due, and then subsequently it was the debtor's estate that was involved in the case. So the other issues, Your Honor, is the dismissal of the unjust enrichment and constructive trust case, not addressed by the trial court. It's undisputed that the payment was made. I'm sorry, I see my time is up.
And you'll have time on rebuttal. Thank you.
May it please the court, my name is Michael Michon of Michael A. Michon PC. I'm counsel for Respondent 3 West 16th Street, LLC. I just want to note the Court of Appeals has for a long time recognized that there's a societal interest in public policy behind the statute of limitations, serving the objectives of finality, certainty, and predictability.
Let's just go back a minute, because there is a procedural issue that needs to be addressed, which is that the court treated as a motion for it wasn't a timely motion to dismiss because it was made after the answer was submitted, and the court, if it was going to treat it as a motion for summary judgment, was required to notify the parties. So why, under the undisputed circumstances of this case, shouldn't we remand it to the court below to treat it procedurally properly?
Because unlike my opposing counsel said, there is, we did raise as the 9th affirmative defense in our answer, the statute of limitations defense, and there is case law that has been cited.
But the case says that if you're going to assert it in your answer, then you can't make a motion to dismiss on that ground. You either have to make a motion to dismiss or assert it in your answer and then make a motion for summary judgment. I mean, that's just what the CPLR says. So why shouldn't we enforce that provision of the CPLR and remand it to the court below to treat it as a motion for summary judgment, since you did put it in your answer?
So what I can say is that there is case law that we did cite, which opposing counsel tried to distinguish, which I don't think can be distinguished. which does say that if you include the statute of limitations defense in your answer and then later file a motion to dismiss based on the statute, that it's still valid. That would be the Goldenberg versus Westchester County Health Care case.
Well, isn't what the CPLR 3211E envisions is that with paragraph 5, you can move on it pre-answer, or you can assert it in an answer and then move on it by way of a summary judgment motion after you interpose your answer. And so here he did sort of a hybrid thing. We moved after the joinder of issue by way of a 3211 motion.
Yes.
And so is this a sort of harmless error type analysis you want us to employ? There are obviously two different procedural devices. So you have styled it and you continue to refer to it as a 3211 motion to dismiss. 3211E would counsel us that the proper thing to do would be to move on that ground on a summary judgment motion. So is this a no harm, no foul situation?
Well, I do think based on the substance, this is no harm, no foul. I think substantively what the appellant is saying is basically we want to exalt this one filing, a proof of claim in a bankruptcy. We want to disregard the fact that there was on the record in the bankruptcy court, there was notice given to the bankruptcy court that these fees were disputed. There was notice of the malpractice action. The bankruptcy court was aware, found that there were no identifiable settlement proceeds, that SGR, the appellant, was not connected to the bankruptcy, and sought, rather than to prejudice our client's recovery in the malpractice action, sought to protect and preserve that right, not to prejudice that right. So I think clearly to take the four corners of the, substantively speaking, to take the four corners of the proof of claim and to suggest that that is an admission. All of the case law that I've looked at and that we've quoted in our papers is ample case law for the idea that you have to look beyond the four corners of the document. These cases that they cite all have representations that go outside of the four corners of the document. The only proof of claim case that they cited in Breyer was a situation where a representation was given quite to the contrary of what was represented. And right after they gave that representation, the party that was seeking to get out of to deny recovery took the opposite tack.
What about,
go
just
ahead.
answer, what about the unjust enrichment claim? That was not barred by the statute of limitations.
Right. So we don't see how there was any unjust enrichment because my client consistently was disputing these fees. To say that there was unjust enrichment means that they got money that should have been, that was being held, that should have been held for the appellant. They didn't get any money that was held for the appellant. There were no part of what they were given did the bankruptcy court say they were entitled to. Quite to the contrary, the bankruptcy court said, you guys, we understand that you have a malpractice action going, which, by the way, they never counterclaimed to and asked for fees there, so that was an opportunity. They could have gone.
Thank you, counsel. Thank you.
We're here on a 3211 motion, and most of what my colleague said appears nowhere in the complaint, and it takes place years after the allegations in the complaint with respect to the restarting of the statute of limitations. So at the very least, this court should reverse on the procedural ground and remand to the trial court. And unless the court has any other questions, I'll rest.
Thank you.
Thank you.
Thank you, Your Honors.
Rivera versus Board of Trustees.
Good afternoon, Your Honors, and may it please the Court, Lauren O'Brien on behalf of the appellants. The Board of Trustees properly granted ordinary disability retirement benefits here. The petitioner was a probationary firefighter whose legs simply began to hurt while he was running during a routine training exercise.
But counsel, wouldn't you agree that dehydration is a foreseeable event, is a routine event in firefighter training
I would agree that it is a foreseeable event in firefighting training in general, and also in the specific exercise that he was engaged in when
But not an accident. Dehydration would not be an accident.
dehydration would not be an accident. For that reason, and also for the independent reason that it is just a health condition itself, and an accident under this court's case law and under the Court of Appeals case law requires a mischance, a fortuitous mischance that is sort of external, and an event that occurs and interrupts the ordinary course of the job duties in order to cause an injury. And here, nothing of that sort occurred. But yes, Your Honor, also for the reason that
So compartment syndrome, you're alleging, is a sequelae, I gather, of dehydration. In other words, there's something that follows from it, but not always. But it did in this case. And that's what you say the accident is?
I am representing the appellants in this case, and we are arguing that there's
right,
no.
of course, I'm sorry.
Yeah, no, that's all right. So.
You're happy about my question?
Yes.
All right,
I
please
was,
continue.
yes.
Exclamation point, not question.
Yes, correct. It was foreseeable. But I will say the compartment syndrome, it's not necessarily clear from the record what the relationship between compartment syndrome and dehydration is. And regardless, the compartment syndrome itself was the injury that he suffered from as a result of this leg pain that arose during the running exercise. And so that on its own is not the thing that counts as the accident that would entitle him to these enhanced benefits. And again, as mentioned, that doesn't mean he's left without any benefits, because his running injury rendered him unable to complete his firefighter training. The Board of Trustees properly awarded him ordinary disability benefits, but he is just not entitled to these enhanced benefits that he claims that he's now seeking. And unless Your Honors have any further questions, we ask this court to reverse the award of those enhanced benefits and dismiss the proceeding. And if this court chooses instead to affirm, we would ask the court to reverse the award of attorney's fees for the reasons set out in our brief.
Any further questions? Okay, thank you.
Thank you.
Good afternoon, Your Honor. Stephen Holohan, attorney of counsel for Napoli Skolnick, attorneys for the respondent in this matter and the petitioner in the lowercase Jorge Rivera, who was a priority hire firefighter hired at the age of 38 to train and become a firefighter. The dehydration in this matter, which the petitioner refers to, was not the cause of the injury. The dehydration is what subsequently led to his injury, which is the compartment syndrome. If he only
Is the
suffered from-
dehydration, same question, is the dehydration a foreseeable event of firefighter training?
I think loss of fluids is. I don't think dehydration is, because it's training. I think firefighting, certainly, because there's no opportunity to pull back and hydrate yourself during a fire because the activity is emergency in nature. This is training. This is an emergency in nature. There's a facility, there's ample fluids there. So loss of fluid should be, but the dehydration itself should be something that's stressed and should be something that shouldn't happen. And if it does happen, indeed, it's accidental because they're trying to prevent it in the first place. So that is the accidental.
What was accidental?
Initially, the dehydration's accidental because they're trying to prevent it, because it's a training exercise. They don't want the firefighters to get dehydrated. It's not part of the training to teach somebody to become dehydrated.
What is the accident? I'm sorry, go ahead.
No, you go.
Go ahead.
Okay. As I read the law here, and I may be wrong on this, so correct me, there seem to be two elements here. You need an accident, and then you need an injury that's caused by that accident.
So yes, this is similar.
Okay, so we agree on that.
Yes.
And I think we all agree the injury here was a catastrophic one, the compartmental syndrome. So we've got that part of the equation. What was the accident?
The accident was the dehydration, was permitting a firefighter during training to become dehydrated in a controlled environment. But for the dehydration, the compartment syndrome doesn't happen.
But isn't dehydration itself a sequelae of an injury, or I'm sorry, of an event?
No, it shouldn't be. Loss of fluid should be, but there should be ample opportunity after the loss of fluids to rehydrate during that time. So this is not a fire. This is not firefighting. It's training. So after the initial training, which took place that morning, the firefighter should have been given an ample opportunity to rehydrate, and had they properly rehydrated, or had he properly rehydrated, we would have never got to the compartment syndrome. So it's similar to an exposure case where
Normally, the cases talk about a fall, someone, an officer, or reaching over somewhere. There's an action being taken. That's the event. That leads to the injury. Dehydration seems like the body's physiological response to being overheated.
So there's other accidental cases where a body's physiological response is indeed the accident. And in those cases, you're going to have cases of exposure to chemicals. So it's not the chemical itself, but it's the body's reaction to the chemical. It's exposure to smoke and to other carcinogens that cause cancers, right? It's not the smoke itself, but it's the body's reaction to the smoke. So in this case, you could have had 150 firefighters that were exposed to the same thing firefighter Rivera was, but they didn't get dehydrated in the way he did. They didn't contract compartment syndrome. It's a similar case to other types of exposures. It's not like an orthopedic
Doesn't that go to the
injury.
unforeseeability of the injury, not the accident?
So I think it's
the case
both.
law, and I just want to quote here from McCambridge. The injury, that's one part of our equation. The injury must be the result of a sudden, fortuitous mischance, unexpected out of the ordinary, and injurious in impact.
So the
The
dehydration
accident has to be unexpected or sudden.
So the dehydration is unexpected and sudden because they had the opportunity to rehydrate. There's no reason for them to become dehydrated in a controlled environment that's training. This is not firefighting. So it's not they're running into burning buildings with the gear on and they have to stay in there for an extended period of time because
Maybe
life
the
is
first time they do that shouldn't be when there's a fire. Maybe they have to train before that.
There's nothing in the record to reflect that, but that's a possibility. But there's nothing in the record which there's minutes from the Board of Trustees which discuss this at length, and half of the Board of Trustees have been through the Fire Academy, and they discuss it at length, and it's in the record that this should not happen. We should not leave a firefighter and let his training let him down to a point where he becomes dehydrated and suffers from whatever it might be, whether it's heat stroke, something temporary, or something as catastrophic as this in this matter.
Thank you very much. I'm sorry, did you have any questions? Okay, thank you.
Good, thank you.
What?
Thinking out loud.
I'll just keep this quick, but I'll just say that it's not, the question isn't whether the injury itself was intended or if the injury itself was unforeseen, because an injury, a catastrophic injury like this is never intended or foreseen. The question is whether there was an unforeseen event that preceded the injury and that caused the injury.
Could the accident here be negligence in or oversights in the manner in which the training was conducted or the supervision of this trainee? Could that be the accident which brought about the dehydration?
I'll just say based on the case law, typically it's something, what's required is a fortuitous mischance. That's sort of the language that's used. To the extent something during the training, perhaps as the result of negligence, could constitute a fortuitous mischance, then yes, I can't say sort of as a general matter. But typically it's, like you said, something like a fortuitous slip in a puddle of water, or someone was moving out of the way while someone was getting up from a chair, and then that caused that person to fall. It's sort of something from the moment to moment that occurs that causes an injury.
What about the medical board recommending ADR?
So first, I'll just say that the Board of Trustees, the medical board is entitled to deference from the Board of Trustees on matters of medical expertise, and so whether the petitioner is permanently disabled, the nature of the injury, but the Board of Trustees does not have to defer to the medical board's determination one way or another as to whether there has been an accident, because that's a legal common sense term. And here, the medical board did conclude that this was an accidental injury, but it didn't didn't point to anything that legally could constitute an accident.
Thank you very much.
Thank you very much.
Richardson versus motor vehicle.
Good afternoon, Your Honors. Shall I start? May it please the Court, my name is Nicholas Delano of Delano Law PLLC, and I represent the petitioner appellant Brittany Richardson, who would ask this Court today to please reverse the lower court's denial of petitioner appellant's petition for leave to sue MVAC, because it not only did it base its decision on grounds that were not even raised in opposition, rightfully so, because MVAC should recognize that its own forum, and with a jurat that says sworn hereby too, which under Spiracco is an affidavit, is actually referenced as an affidavit no less than 14 times in Insurance Law 5208. It wasn't admissible form. The prima facie data is there for the fields, for the applicant to fill in, and it was there for the lower court to deny it on those grounds. But even if you were to consider the respondent's opposition, this would seem to be almost an issue of first impression, where there's two tortfeasors and one of them is an offending vehicle. And if you were to look at the purpose of the statute, Motor Vehicle Accident Corporation Act, which has a history of at least putting a victim of a motor vehicle accident for which there's no insurance available for an offending vehicle, this is a perfect situation for that to be applied, especially in light of the petitioner's injuries, which can be demonstrated in the photographs, and she's underwent numerous injuries, including an ankle surgery. Even both policies of $25,000 that they were in play would not satisfy the level of injuries that she had. But that aside, the statute in itself is consistent with the purpose, and the offending vehicle this isn't a summary judgment motion. This is simply a petition for leave to sue MVAC. The actual merits of who's responsible can be determined later on. I know that the respondent cited certain cases. They're all distinguishable, and I'm prepared to discuss each one how they are, if you'd like. And the argument that the other vehicle for which the owner and the operator are known should be sued first is not going to ever afford the opportunity for an injured party like this to have justice through MVAC, because the statute of limitations will run out by the time that case is perhaps tried or have a determinative motion decided on that case. So with respect to, I'd like to go, and if Your Honor would like, in order through the respondent's cases. With respect to Vega versus MVAC, that case, for which they're arguing that the petition must contain proof in admissible form.
Counsel, the police report, they're contending it was hearsay. What do you say to that?
Well, that one I would say there's no objection to that, and the court may consider it admissible hearsay. There's no objection. Not only was there no objection, but it was included in the opposition papers from the respondent. So they actually wanted to incorporate it in their own arguments, and therefore there should have been no grounds to not consider the police accident report, since it was even in MVAC's own papers.
And substantively, it's consistent with your client's account of the accident.
Absolutely, Your Honor. Yes. With respect to Vega, in that case, there was no opportunity for the claimant, anyone with firsthand knowledge, to have submitted an affidavit such as the one that Ms. Richardson did here, because the claimant was killed in that accident, and therefore the court had its hands tied. There was nothing in admissible form, because the police accident report was not in admissible form and perhaps wasn't included in the opposition. Here is completely distinguishable, because not only did Ms. Richardson have firsthand knowledge, she laid out all the prima facie elements in the affidavit, which was notarized by a jurat, but the police accident report also was submitted in opposition. With respect to the other cases, basically they involved, cited by an opposition, basically involved cases in which the driver and the owner were known and ascertainable. This is not the case here, as there was The registration didn't even come up when the police did their investigation. And they listed there is no insurance that came back for the vehicle. And this is the picture-perfect case why this should be applied in a situation where there's two tortfeasors and there's a offending vehicle for which there's no insurance. If Your Honor have no further questions, I'll defer the rest of my time.
Thank you.
Thank you, Your Honors.
May it please the court, my name is William Badura. I'm here on behalf of MVIC. It's MVIC's position that the lower court was correct. The lower court found that basically the petitioner did not submit sufficient proof to make a claim or to establish.
What more proof is required from what the petitioner has already submitted? A notice of claim, basically, which is signed and notarized by the petitioner. An accident report that no one objected to that basically says that the offending vehicle has no insurance, that the plates that were attached to the vehicle don't belong to the vehicle. A letter from the insurer of the one vehicle that does have an owner and did have a driver there that says that they disclaim because their insured had nothing to do with this accident. It's not responsible, not liable. And the driver of the offending vehicle, the Cadillac being in this case, fled the scene, so there's no information on who actually owns the car, that vehicle, and there's no insurance. What more do you need?
Well, there's available insurance. This is a two-vehicle accident. One of the vehicles was insured. That's in the record by Geico.
And that's the one that disclaimed.
Okay. And the fact that Geico denied liability, they must do that numerous times each day, and then people put the case in suit, and that's what determines if they're insured is negligent or not. And that's the whole case here. MVAC is a remedy of last resort. And here's available insurance. It should be, how there should have been is that the identified party should have been sued and a determination made there whether they're liable or not.
What about his counsel's point that the statute of limitations would run if we proceeded in that way?
Well, you can see it done where you name, just like any other two-vehicle accident. Here it'd be the named vehicle, and the other would be MVAC on behalf of the unidentified vehicle. But that's not how this was set up. That's not what was presented to the lower court, and that's why they're correct, in my opinion. MVAC is a remedy of last resort. There's no doubt about that. And here there's available insurance. All you need is 1% against that other vehicle. And then MVAC is off the hook.
Okay,
And that's what their
so
statutory
based on
rights
the
are.
accident report, the Cadillac ran the light, struck the BMW, and then subsequently somehow got into a spin and struck the plaintiff that was crossing the street in the crosswalk with the light in the pedestrian's favor. How is the BMW even 1% responsible for that?
Well, again,
Based
that's-
on what's in the accident report.
Again, just from, you can question the insured vehicle's operator. Did they look before they entered into the intersection? If so, how far could they see? They may say, yeah, I looked into the intersection, even though I had a green light and I can see this car coming. But what did you do? I didn't do anything. Did you brake? No. Did you steer in the direction to avoid a vehicle? No. There's 1% right there. And that'd be upheld by, I think, any court.
Okay.
Any further questions? Okay, thank you.
Thank you.
Your Honors, I think it would be important to note that the two cases that were cited by the respondent with respect to the proposition that only if the action against a known operator and owner fails may lead to suit MVAC be sought, those cases held this important point that only if the personal injury action ultimately fails due to the lack of proof of identity of the owner and/or operator may lead to suit and be considered. This case that would be on a verdict sheet as to whether or not the question of fact as to whether or not the person that's party to that action, that trial, is actually the correct identity of the operator or owner of the vehicle. This is not the situation here, and there's nothing in the statute that prohibits full compensation to a victim of a car accident, even if there are two vehicles even if the other vehicle is 1% at fault. In order to get a full compensation, put the victim in the shoes as they would have been if there were available insurance, that would be, inconsistent with the purpose of the statute to hold otherwise.
Thank you very much.
Thank you, Your Honors.
People versus Savage.
Hi, good afternoon, Your Honors. If it pleases the court, now to arrive from the Legal Aid Society on behalf of Appellant Roy Savage. While the lower court correctly suppressed Mr. Savage's initial videotape statement because it was obtained in violation of Miranda, it should have also suppressed a subsequent statement because there was no evidence that taint from the initial interrogation had dissipated by the time of the second interrogation, and they were part of a single continuous chain of events. Specifically in this case, after the officers read Mr. Savage's Miranda rights, they went on to undermine them explicitly in an effort—
Counsel, why isn't this case like People v. Gomez, where there was an incomplete statement of Miranda? They left out the part about having counsel paid for, I think. And then, and that interrogation was suppressed, but then a subsequent interrogation where their full Miranda rights were read, that the results of that interrogation were not suppressed. How do you distinguish that?
Here, the Miranda violation wasn't that he wasn't given a complete explanation of his rights, but the officers actually undermined them, right? The officers told Mr. Savage that, in fact, contrary to Miranda, that his statements may not necessarily be used against him. Also told him that these rights are read to everyone and it's just no big deal. And then during the course of this 2.5 hours of interrogation, the officers suggested that the statements that he may actually be used to help him in order to get a better, get the benefits of a more lenient sentence. So under these facts, it's not that he didn't know what his Miranda rights were. When he was read the Miranda rights, he believed that it meant that even though by the time the DA gave him the Miranda rights a second time, even at that point he was told you have the right to remain silent. These words you say will be used against you. But he actually may have believed that in fact they might not be used against him because the officers told him.
What about the fact, assuming that the first Miranda warnings were no good because of the statements the police officers made, it was hours later when he gave the statements to the district attorney. Why wasn't that sufficiently attenuated, particularly in light of the fact that at that point there was no dispute that he was under arrest and going to be prosecuted? There was no ambiguity about that anymore. So any earlier statement about how they wouldn't be used maybe against him was dissipated by the fact that he knew he was being arrested.
Well, a few things. So during the interrogation, it wasn't just that he was told that his statements may not necessarily be used against him. They suggested that his statements may actually be used to help him, right? Maybe used to help him to get a more lenient sentence, and that his continued cooperation with the quote-unquote legal process was part of the packet of getting a more lenient sentence. And so by the time, and then nothing happened, and so he was never told that. That might not be true. He was led with the impression that, but when the prosecutor, he was led with the impression that he continued to have the same belief, right? There's nothing that happened that would have changed his mind to not believe that.
Let me ask you another question then, because there's no way that the DA could know generally what happens at the first question when they go in and do the second questioning. So are you arguing that a situation like this, where there's a problem of this type with the first warnings, that there's no way to really correct it ever because it's just tainted the proceeding to such a degree that there could never be a proper confession in this case?
I'm not 100% sure how we could have corrected it. Like, one thing the DA could have done is, we know this the initial statement was videotaped, so she could have viewed the videotape. She knew the statement was videotaped. She had said that. She knew that there was a initial statement given, and she could have reviewed the videotape to see how the waiver happened. But I don't know in a case like this whether there's a way to fix this Miranda violation, because it so infected his understanding of Miranda. And anything that and there was really and the fact that, it's really unfair to use the fact that he now believed that he would be arrested, which was that belief only came about because of the Miranda violation, is used as the thing that creates some sort of pronounced break, right? Because he wouldn't have believed that. He wouldn't have come to that belief had the Miranda violation not happened. And it's just further evidence that he was still under the influence of the initial interrogation.
Can we decide this appeal with the Pullman framework, or would we have to create a new rule to address it?
I think the Pullman factors are not definitive, but I do think that I think the significant Pullman factor in this particular case is the circumstances surrounding the initial Miranda violation. And the circumstances surrounding the initial violation isn't that he wasn't given the Miranda rights; it's that he was given a totally his understanding of Miranda was completely distorted by what the officers told him.
Go ahead.
And so to that extent, I think we can look to the Pullman factors, but I think the other factors that the DA has cited in terms of like the time lapse, the location, the difference in location, none of those things would have really changed what Mr. Savage was led to believe by the officers during the 2.5 hours that he was being interrogated.
And are these cases, do you think, similar to Chappell or Capel, I might be mispronouncing that, and Bethea, where the Court of Appeals highlighted the fact that there were the unmirandized statements were extensive and were not given, the defendant had not volunteered to give the statements in the first instance. It was more in response to the custodial interrogation?
Exactly. I mean, to the extent, yes. And I think it's even more egregious in this case, but yes. I think that the fact that Mr. Savage didn't initially want to actually waive his rights to Miranda. It was only after minutes, you have the video, but it's clear that it was over a course of several minutes back and forth about talking about what Miranda meant, that and totally undermining them, with the officers totally undermining the Miranda statements. Did Mr. Savage agree to speak?
Thank you.
May it please the court, Charles Wan for the respondent. Defendant's second video statement was made over 3 hours later in a separate room before an assistant attorney and a detective who were not participants in the first video statement. And as the hearing court found, at the time of the second statement, defendant knew that he would most likely be arrested and that his statement can be used against him.
Let me ask you, because this really is a somewhat unusual case. Because normally what comes up is that you didn't get a Miranda warning when you gave your first statement, or the Miranda warning was incomplete, but there really is a compelling argument under the circumstances of this case that it was misleading, and that they sort of said they didn't give the part of Miranda warning that this could be used against you. They gave it, but then they took it back by the statements they made. That a strong argument could be made to that effect. And if that is true, how could just time, normally the time and attenuation supports upholding the second statement, but in this case, it doesn't. How does it correct the misunderstanding that was created by the statements in the first confession?
Well, it's not just the time, it's all the factors mentioned in Pullman case. There was a change of the location, and the statement was given by, the questions were asked by different individuals.
Those are all cases, all the cases that are discussed are cases where it was an incomplete or it wasn't given, but this is a case where arguably there was a misleading warning, not an incomplete warning. And when it's misleading, does the regular attenuation requirements really make sense to apply? Because the fact that 4 hours passed, there was different people, a different room, how does that remedy the initial deficiency, which is that he was giving a misunderstanding of what Miranda rights meant?
I believe the criteria on the Pullman is not so much what was the initial Miranda violation, but is there a pronounced break?
Is this
Right,
a
but,
single continuation?
I guess what I'm trying to ask you, and the cases don't really talk about this very extensively, even if there is a break, if the initial problem was a misrepresentation of what the Miranda rights were, what good does a break do, even if it's a 10-hour break, if he was never given a correct understanding of what Miranda meant?
Here, the assistant district attorney read the proper warnings, and as the hearing court found, it's based upon defendant's first statement, it was clear that he understood that the statements would be used against him, and that that he was that he was facing an arrest here.
When he was interrogated by the assistant district attorney, he made reference to the statement that he gave the detective, because he says, I'll make a long story short, because I already spoke to the detective, this is what happened, right? And he gives his version of what happened. So it appears that at that point, he's still under the impression, given the misleading warnings that he received, that it would be in his interest to speak to the assistant district attorney.
Well, Your Honor, here the defendant did not testify at the hearing, so he did not carry his burden of persuasion that he might have been under the impression that he needed to testify to clarify his first statement.
But he was told by the officers that it would help him if he spoke to them. He was told that his statements would not necessarily be used against them. He was told that he was not under arrest when in fact they knew he was not free to go. They were going to be arresting him. He was told that he was also told, aside from those things, that I forgot my train of thought. So he's told those things, and he's under the impression that he can speak to them because it will be in his best interest, because that will help him get a lower sentence. So when the ADA comes in, might as well speak to this lady also.
Well, Your Honor, the hearing court actually found that the defendant knew that his statements could be used against him and that he would be arrested. So under the circumstances, the hearing court found that the people had met our burden, that there was a pronounced break. So it would have been up to the defendant's burden to persuade the court that, no, he still was under the misimpression, but as he did not testify, there was no way of knowing what he actually believed, and he did not satisfy his burden of persuasion in this case to have the...
But even when he testified at trial, he was still making reference to the fact that he spoke to the detectives at the precinct. He was still making reference to the fact that he spoke to the assistant at the precinct. So he was still, even at that point, under the impression that that misleading Miranda warning somehow was going to be helping him in the future.
Well, at the trial, we don't know what he was thinking, Your Honor, because he never actually even stated it. He might have just been trying to, I don't want to read into what his thoughts are. At the time, he's trying to help himself, so we can't
That's exactly why he spoke to them, because he thought that that would help him.
No, yeah, I mean, what I mean is him referring to the first statement, it could be he's trying to make it show that the second statement is tainted and trying to help himself. But he never actually really stated, even at the trial, that I actually believe that I had to talk, they would help.
Did he have to do that when the officers themselves said to him that it was in his best interest to speak to them?
At the hearing, he had the burden of persuasion, so once the court decided that people had met a burden of proof, that there was a pronounced break, it would have been up to him to establish that the second statement was given in light of the first statement. Thank you, Your Honors.
Thank you.
So the burden remains on the people to show that by the time of the second statement, that he was no longer under the influence of the initial interrogation, and the burden wasn't on. This is an objective inquiry, and it doesn't require our client to testify at the suppression hearing to say what his state of mind was. It was from the objective circumstances. It was obvious that there was nothing that happened that would have changed his mindset, that would have made him not believe what the officers had told him for 2.5 hours, that talking to the police was going to be something that was going to be helpful to him, to be beneficial to him. Just because of time, I just also want to get to the third point, just very briefly. We asked the court, if the court is not inclined to grant a new trial, to reduce Mr. Savage's sentence. I just want to note that Mr. Savage has led a law-abiding...
Sorry, you what?
I'm asking the court to reduce Mr. Savage's sentence if the court isn't inclined to grant suppression and a new trial. Mr. Savage has led a law-abiding, productive, and violence-free life for the past 2 decades, earning his bachelor's degree at age 30, working as a social worker for 13 years. At the time of offense, was enrolled in school and was a month away from earning his master's degree in mental health counseling, and had no run-ins with the criminal legal system. And just to note that we're not asking that the sentence, we're not asking for him to get out soon. We're just asking for him for the possibility that he may be released on parole earlier, and that determination will be made by the parole board. And we're just asking that he sees a parole board earlier than when he's like in his 70s.
Thank you.
Thank you.
Thank you. Nice to meet you.